to the momentous occasion of 280th session of Legal Empowerment Through Interaction Exercises. There has been occasions, and when we say that such and such person has not entered the box, could we say that it's a we could draw an adverse inference against that person? And there are also occasions wherein can we compel the respondent defendant to enter the box. All these issues, especially both on the civil and criminal jurisdiction, will be dealing with in this short span of time, and that too by a master of the subject, Sunil sir. Sir, welcome to this platform, and may I also welcome Justice Ramkumar sir and Justice Ramakrishnan sir, and all of you wonderful participants to this 280th session, wherein we'll be dealing with a very, very particular topic, which has vexed and at times we were perplexed. And that's it. Over to you, sir.
Thank you, Mr. Shyam. Respected and honorable members, I'm so happy to join this legal refresher program. And it's so wonderful that you have crossed the 279 programs, and this is the 280th session. It's an amazing thing. Mr. Shyam Padman, I should specifically congratulate you for, I know the difficulty how to organize a function, to find out the resource persons, and to keep all the audience intact. It's fun. You have been doing it for the last 2 years. So let this continue for a few more years, and because ultimately this becomes a permanent record, which can be used by those who come to the profession, who are already in the profession, even the law students. Today, the topic that we are going to discuss is regarding the concept of adverse inference. Now, we all know what is the burden of proof. That is specifically referred to in the Indian Evidence Act. Specific provisions are 101 to 111. I may say these are the specific provisions which lay down the burden of proof in relation to civil and criminal adjudication. And if you go through that, these provisions, what you will find is that they fix the responsibility on certain persons regarding the burden of proof vis-a-vis the subject matter involved. Section 101 says that if anybody claims any legal right or a liability based on certain essential facts, burden is on that person to establish those facts. And Section 102 says, in the case of a civil suit or any other legal proceeding, in any suit or any other proceeding, civil and criminal proceeding, burden of establishing, the burden lies on that person who is likely to fail if no evidence is adduced by either side. These are the two core principles of burden of proof, and supplemented by the remaining provisions. 101 to 111 fixes the responsibility on the parties to the litigation. Who has the burden of proof? The cardinal principle of burden of proof is that never shifts from one party to another. It remains static. I'll just start by giving you a citation which fixes this responsibility. That decision is in Arumugan versus Sundarambal, AR 1999 SC 2216. That was from a slightly advanced position. I will just give that citation and tell you the principle. In Arumugan versus Sundarambal, AR 1999 SC 2216, what the Supreme Court said was that burden of proof is fixed, and once both sides adduce evidence or when the trial is completed, the concept of burden of proof loses its significance. It pales into its insignificance. Then what remains is only the appreciation of evidence by the courts. Depending on the question whether the person on whom the burden of proof was imposed has discharged his burden. So essentially, the concept of burden of proof has its life till the evidence is adduced or placed by both sides. But in the course of, so this is what the decision says. But when a person who is bound by the law to prove a fact tenders his evidence, what happens is that onus of proof shifts to the other side. And what happens is that if the other side discharges the liability, then again we go back to the same principle, law of evidence is adduced. So in the course of trial, though the concept of burden of proof remains static and it never shifts from the one person to another, the principle of onus of proof shifts from one person to another. Or you can say that in certain cases, it oscillates between the parties. So when one matter is established by the other side, the exception to be established by the other side. Then we discharge the burden, reverse onus of proof may come in on the person who let in the evidence first. So that the principle that I'm just trying to make you understand is that in the case of a burden of proof, it remains static and it never shifts in the course of evidence. The concept of onus of proof shifts from party to party, and there is one decision which says that it oscillates in the course of trial. That decision also I will just refer to. That is in Addagadda Raghavamma, A. Raghavamma versus Addagadda Chenjamma. AR 1964 SC 136. Addagadda Raghavamma versus Addagadda Chenjamma. AR 1964 SC 136. So what the Supreme Court said is that the distinguishing the concept of burden of proof and the onus of proof. This is what we know in principle. Now, burden of proof being a static one. In certain cases, the party who has got the burden of establishing a fact may not be equipped with the complete materials to establish his case. It may happen that the material which he wants to establish, the fact which he wants to establish, the entire evidence may not be in his possession, but crucial evidence may be available with the other side. It invariably happens. One typical example which I can give you right now is a case wherein employer-employer relationship is in dispute. Necessarily, the service records relating to the service of that person, the records regarding his employment, unemployment, etc., terms of employment, etc., will normally be available with the employer. It may be possible that the workman may not be in possession of the crucial documents. That may happen in every type of litigation. So what happens is that, then how to establish that fact? Here comes the aid of one principle under the Indian Evidence Act, which is the subject matter of today's discussion, that is the concept of adverse inference. The law regarding adverse inference you can find in section 114 G and H of the Indian Evidence Act. 114 G and H says that, or 114 as such deals with the concern regarding certain presumptions which a court is entitled to draw. It says that the court is entitled to, when a question regarding the existence of a fact arises, the court, having regard to the common course of conduct of parties, the relationship between the parties, the conduct of the parties, and the private and public business of the parties concerned, may arrive at certain presumptions. That is the power given to the court under section 114. 114G says that when a person who is bound and does not produce an evidence, The presumption which the court can draw under section 114 is that if he produces that document, the finding will be adverse to him. This is the presumption which the court can draw having regard to the facts and the circumstances of the case, course of common course of nature, and the relationship between the parties. So, under section 114Hg, a court is entitled to draw an adverse inference if a person withholds a document, not a document, withholds evidence, which he is bound but under which he does not produce. The court may, that means court may draw a presumption. It is not a mandatory provision at all. I'll come to those principles later. So for the time being, you keep in mind that 114G enables a court to arrive at a conclusion, raise a presumption that a person who withholds a crucial document, a person who is bound to produce a document but he does not so, court can draw the presumption that he withholds it because if it is produced, that may go against him. The second presumption is regarding the giving of evidence, oral evidence, answering to questions under section 114H. When 114H says that when a person refuses to answer a question which he is not bound by the law to answer, the court can take a presumption, court can draw a presumption that he refused to answer the question because that may be adverse to him. So, two aspects. 114G relates to non-production of documents. 114H relates to refusal to answer to a question. In these two circumstances, the court can draw a presumption that he either withholds the other side, a person who is bound or a person who is called upon to give evidence, produce the evidence, refuses to do so, or he refuses to answer it because if it is produced or it is and question is answered, the conclusion it may go against it. So these are the statutory provisions regarding adverse inference. Then the question comes: whenever a person withholds a document, can the court take an adverse inference? Whenever a person refuses to answer a question, which he is bound to answer, which he is not under an obligation to answer, still can the court take an adverse inference? There are a lot of legal decisions on that. The basic principle regarding or consistent law regarding the concept of adverse inference is that it is not a necessary inference. It is only a permissive inference. Or section 114G and 114H permits the court to draw an adverse inference, but it does not. It's not a necessary inference. It is not necessary that the court should always draw an adverse inference. In one decision, the court said the court is not expected to draw by a mechanical process, draw an adverse inference. That citation I will give you, that is in Harpal Singh versus Devinder Singh. Harpal Singh versus Devinder Singh. AR 1997 SC 2914. The court said, after an evaluation of the concept of adverse inference, concluded that it is only a permissive inference, not a necessary inference, and that the court should not draw an adverse inference by a mechanical process in every situation. So that is not a mandatory one. Court has to take into consideration various other inputs, various other factors, etc. What are those factors? We will discuss. Then another principle which through various decisions which the Supreme Court has laid down is that adverse inference is a question of fact and not a question of law. It is a question of fact and not a question of law. And one more cautionary principle which the Supreme Court has laid down is that adverse inference can be withdrawn only in circumstances where the best evidence is withheld, not in every case. So these are the core, basic, important, significant principles which the Supreme Court have laid down. We will go into that in later. Now, what are the advantages of drawing an adverse inference? How does it help the party? Or what are the advantages of drawing an adverse inference? So what are the advantages of Section 114G and H insofar as a civil or criminal adjudication is concerned? The first principle, first advantage, there are two advantages. I may generalize it and say. The first one is that by an order of the court, the opposite side can be compelled to produce the evidence, and thereby it facilitates the adjudicatory process. So one of the most important advantage is that it facilitates the trial of a litigation. How? Not by producing a document, but by calling upon the opposite side at the instance of a person who has got the burden of proof, calling upon the other side to produce the evidence, and he fails, request the court to draw adverse inference. Thereby, one person cannot bypass the judicial proceeding or cannot steal a march over the adversary by withholding the crucial document or crucial evidence which is held by him. Or in other words, the litigation process cannot be nullified or defeated by withholding a crucial document which he is in possession. So that's the one advantage, it facilitates the trial. The second advantage I may say is that it imposes a duty on one person it enables the party to advance a positive case. It enables a person to advance a positive case even if he is not holding the material evidence. Or that, in other words, the advantage is that a person will not be denied of the justice merely because of the fact that he is not holding the crucial material evidence. He is still likely to succeed, or he is in a position to advance a very positive case if the material evidence is held by the other side. These are the two advantages of that. Now we will just try to understand what are the circumstances when concept of adverse inference can be drawn. I will generally say the concept of adverse inference can be drawn firstly in cases wherein one person withholds the document. Second is a case wherein one person refuses to tender oral evidence. I'll broadly divide that. The first one we will go into what are the circumstances when a person, that is when evidence is withheld by a person. I will straight away take you to one decision of the Supreme Court in which the principle of adverse inference was directly implemented and applied. That is in RM Yellatti, Yellatti versus Assistant Executive Engineer and others. 2006, 1 SCC 106. That was a case wherein a workman claimed that he has been illegally denied the employment. So his essential basic case was that he was employed by the employer continuously. Under the Industrial Disputes Act, a person will be deemed to have been in continuous service under an employer if he has worked on 240 days in a year. So that if one person is engaged during 240 days in the course of, during a 1 year period, under law, it will be deemed that he was in employment. What he did was that he entered the box and said that I was employed by the executive engineer. I was given work. I used to go there. I used to do work from morning till evening. He never used to give me any receipts for the salary paid to me. Every day I used to sign the must roll. Attendance register is there. All the supporting documents are with the employer. I don't have any document, but he asserted that he was engaged on 240 days. Then he filed an application calling upon the executive engineer to produce the document. They refused to produce it. The court said this is a typical case wherein a concept of adverse inference can be invoked, having regard to the facts which the Supreme Court narrated. One, the workman entered the box. He tendered evidence on his side. Two, he called upon the other side to produce document. The document which he called upon was the best evidence which could have, or the crucial evidence which could have answered the issue involved. So since the best evidence was admittedly in the custody of the respondent, management, and they refused, the Supreme Court said the concept of adverse inference can be invoked. Give you the other example. Just the reverse happened in an identical matter. That was in Mahendra Jain and others versus Indoor Development Authority. Mahendra Jain and others versus Indoor Development Authority. 2005, 1 SCC 639. In that case, exactly identical situation came up. Workman claimed that he was permanently employed. He said that he was employed during a period of such and such year. Though he tendered evidence, oral evidence, his evidence was demolished in the cross-examination even. He could not even specifically pinpoint the period during which he was employed. So the Supreme Court said, then he called upon the other side to produce the document. Supreme Court said, concept of adverse inference can be drawn only if primarily the person who has got the burden of proof discharges his obligation. In this case, the workman himself failed to establish his case. Could not establish even with sufficient evidence. The court said he is not entitled. The court will not draw adverse inference. So it's just a reverse situation. I'm just trying to make you understand that adverse inference can be drawn in situations where primarily the person having an obligation to draw evidence, to adduce evidence, discharges his obligation. Or in other words, the concept of adverse inference cannot be drawn from a vacuum. It can only arise if primary responsibility is discharged by the one side. Then I will take you to one more important decision, wherein the concept of adverse inference was dealt with in more detail by the Supreme Court. That is in Union of India versus Ibrahim Uddin. Union of India versus Ibrahim Uddin, UDDIN. 2012, 8 SCC 148. 2012, 8 SCC 148. That was a case where the Supreme Court directly considered the scope of adverse inference. The court reiterated the earlier principle that it is only a permissive inference, not a mandatory inference. It reiterated the principle that court shall not mechanically draw the concept of adverse inference. Whether the court should draw adverse inference depends on various factors. What are the factors? The court laid down 4 important factors to be taken into consideration before drawing adverse inference. The first one was that the court should analyze the pleadings of the parties, answer the question whether any document was withheld, Two, whether the document was an important, crucial document. And lastly, whether if at all document is withheld and if it is produced, it will has got any relevance. So the first principle that the Supreme Court laid down in within this case was that it should be the adverse inference can be drawn having regard to several factors. One, the pleadings of the parties. Two, whether a document has been withheld. Three, whether a document is of a relevant one. Lastly, even if it's a relevant document, will it advance the case of the party seeking adverse inference? On a cumulative evaluation of these things, only the court can order take adverse inference. That is the first principle which the Supreme Court laid out. The second principle which the Supreme Court laid on is the court should always have in mind who has the burden to prove that case. Or in other words, what I'm trying to impress upon you is that by the process of invoking adverse inference, the court should not completely put the burden on the other side to establish the case otherwise. The court should always have due regard to the burden of proof, on whom the burden of proof lies. That's the second principle. The third principle which the Supreme Court said was that the court should consider whether there is any scope for interrogatories being invoked or interrogatories being called for or for inspection of documents. Or in other words, before drawing the adverse inference, the court should consider whether there is any scope for invoking Order 11 of the Code of Civil Procedure. I'll tell you the reason why. There is one reasoning why the Supreme Court said that. The reason was that Supreme Court was of the opinion that Order 11 in a civil proceeding is very wide power, very effective power to a party to bring in evidence. That gives a very, very effective method of either by calling upon by administering interrogatories or by invoking the provision for. That's a very effective provision under Order 11. When the case can be advanced by invoking Order 11, the court need not go for a presumptive inference under Section 14. This is the crucial difference. Order 11 confers a very positive right on a person to administer interrogatories and also for asking for inspection of the records held by the other side. When such a very effective provision is there, why should the court have recourse to the presumptive power? So the court should rule out the possibility of invoking Order 11. So that means adverse inference normally in civil cases, it may not be invariably possible in every case or every case, even in the civil case. What the third condition the Supreme Court laid on was that you should rule out the possibility of invoking Order 11 of the series. The last principle said was that the court should consider whether the court should invoke the adverse inference only if it is convinced that the person who has not the burden of proof has discharged the burden. These are the four principles which the Supreme Court laid down in this case. This covers almost all the basic principles regarding adverse inference vis-a-vis adducing evidence. One question will arise. Is the court competent to invoke adverse inference even without the other person being called upon to produce the document? I will tell you one decision in which the Supreme Court said that it is not essential that the person who has got the burden of proof should file an application, call upon the other side to produce the document or evidence, then only invoke the concept of adverse inference under Section 114. That decision is Gopal Krishnan Ji Kedkar. Gopal Krishna Ji Kedkar. Kedkar. Gopal Krishnaji Kerkar versus Muhammad Haji Latif and others. Muhammad Haji Latif and others. AR 1968 Supreme Court 1413 1413 Gopal Krishnaji Kerkar versus Muhammad Haji Latif. AR 1968 SC 1413. In that case, what the Supreme Court said was that there is no principle involved in 114G and G. This states that the court can draw adverse inference only after an application is filed, calling upon the other side to produce a document, and if you refuse, then only invoke the principle of adverse inference. But you will find that in the subsequent course of decisions, the Supreme Court seems to have diluted that view and said that unless you make a demand, unless you call upon the other side, how you'll know that he is withholding the document? That seems to be, I'm just referring to that decision only to show that at least in one case, the Supreme Court had taken this view. Invariably, this doubt arises. Unless you call upon the other side to produce a document and ask him to give you an explanation, then how can you draw adverse inference? So these are the provisions of law relating to withholding of evidence. Now we come to the phase where suppose the crucial witness is withheld. Can the court invoke adverse inference? That also comes under 114G. When a material witness is not examined in a court of law, can the court take adverse inference? This question was considered by the Supreme Court in Gajendra Singh versus State of UP. Gajendra Singh versus State of UP, AR 1975 SC 1703. Gajendra Singh versus State of UP, AR 1975 SC 1703. In that case, the Supreme Court held that a crucial witness was not examined. And on that basis, the Supreme Court drew an adverse inference, invoking 114G. The same thing happened in Sawal Das versus State of Bihar. Sawal Das versus State of Bihar, AR 1974 SC 778. But in yet another decision, a slightly different situation arose. That was in State of Gujarat versus Raghunath Vamanarao Baxi, BAXI. State of Gujarat versus Raghunath Vamanarao Baxi, AR 1985 SC 1092. In that case, in the course of tendering of evidence, one witness was offered by the prosecution. That was in the criminal case. Prosecution offered one witness to examine. The other side did not avail that opportunity to cross-examine him. In other words, while one witness was being examined, an offer was made by that witness that prosecution, to my knowledge, will be examining the other side if the other side demands, something like that. That was not availed by the other side. The Supreme Court said that if one opportunity, it needs only be a tendering of evidence by one side, then adverse inference cannot be invoked. Then comes Gopal Singh's case, which I referred to in the beginning. Harpal Singh's case. Harpal versus Devinder Singh, which I referred to at the introduction stage. Harpal Singh versus Devinder Singh, AR 1997 SC 2914. In that case, the Supreme Court said, in the prosecution, in the criminal prosecution, Can the court always take an adverse inference merely on the ground that a crucial witness has not been examined? What the Supreme Court said was that ultimately it's for the prosecution to decide which all witnesses should be examined. If several witnesses have given the identical, say few eyewitnesses have given evidence, why should the yet another eyewitness be also be examined? Prosecution has got the discretion to give up a crucial witness if it finds that sufficient evidence has not been brought in. Anyway, what the Supreme Court said, it is ultimately for the prosecution to decide who all are the witnesses to be examined. Merely because one crucial witness has not been examined, the court is not expected to draw an adverse inference. It should always take into consideration consider all relevant inputs and decide. That's why that was in that background the Supreme Court said the court should not invoke adverse inference by a mechanical process. Then comes another decision that is in Marua Day, M-A-R-U-A, Marua Day, and others versus Muralidhar Nanda and others, 1999, 1 SEC 377. In that case, the Supreme Court laid down the principles governing the adverse inference, especially in criminal prosecution. The court said, the court should evaluate all aspects and decide whether the given witness was essential and it was purposefully withheld. One ingredient was the Supreme Court laid down was that whether the witness was in the position to give relevant and material evidence. That is one criteria which the court should go into. 2, whether the witness was not examined was within the reach of prosecution, or whether there were some compelling reasons why the prosecution did not examine that witness. Say, for example, in the case of a witness who was not available for examination, the prosecution may be justified in giving up that witness. In certain cases, the prosecution has feels that the witness, on justifiable grounds, prosecution has a reason to believe that the witness may turn hostile. In such case, also the prosecution may decide not to examine. The prosecution has got a justifiable cause. Merely on that basis, on such circumstances, the court should not invariably draw adverse inference. Third circumstance which the court should consider is what is the nature and intensity of the controversy raised by both sides. And on that particular issue, from the nature of the controversy set up by the parties, was this witness a relevant witness? Lastly, the court should also consider the statement given by that witness at the time earlier, which is on record. So, on evaluation of these facts alone, the court should conclude whether witness was a crucial witness and that he was an essential witness and it was purposefully withheld by the prosecution. Then only the concept of adverse inference can be invoked. The latest decision on this point is Iqbal Basit, B-A-S-I-T-H, Iqbal Basit versus N. Subbulakshmi, 2021 2 SCC 718. 2021 2 SCC 718. That's the latest three-judge bench decision on the principle of adverse inference. That was the case wherein matter related to rent control. The person who had the direct knowledge, who was the defendant, did not enter the box. What he did was that he he filed a power of attorney. He required his brother, who was his power of attorney holder, to give evidence. The court said there was no reason for why the defendant did not enter the box. It also found that several crucial matters were within the exclusive knowledge of the defendant. On that basis, the three judges bench of the Supreme Court held that adverse inference can be withdrawn. So we have discussed two aspects. One, withholding of crucial evidence. Secondly, withholding of crucial witness. What are the parameters which the court should take into consideration while drawing adverse inference? Now we come to a slightly different concept of criminal prosecutions. How far this adverse inference can be invoked, especially when accused have a right to remain silent. So whether the concept of adverse inference will in any way be contrary to the concept of right to silence by the accused. Can the court, what are the circumstances when the court can invoke adverse inference? We all know the basic principle regarding the law which was laid down by the Supreme Court in State of Bombay versus Katikalu Ogad. When a person was called upon to give his handwriting under Section 73 of the Written Evidence Act, whether it will amount to compulsory or compulsory incrimination, self-incrimination, the citation is AR 1961 SC 1808, which is a classification on the point, whether it would amount to self-incrimination. A person who is called upon to give his handwriting for being forwarded to the expert for examination. Supreme Court said, you are not incriminating yourself by giving your handwriting. You are only facilitating the collection of evidence. Thereby, there is no incrimination. So that when an accused or a defendant is called upon to give his handwriting, his specimen signature, or when he is called upon to give his photograph, take his photograph, measurements of the body, fingerprint, footprint, etc. Under Section 5 and 6 of the Identification of Prisoners Act, Supreme Court said it will not amount to self-incrimination. This remains to be the law right now. Subsequently, on that point, another decision which you all know came up, Shelby versus State of Karnataka. That was in AR 2010 SC 1974. AR 2010 SC 1974. That was a case wherein the question whether if a person is called upon to undergo narco analysis or chemical narco analysis, lie detector test, and beep test. These were the three issues involved which came up before the Supreme Court in Shelby versus the State of Karnataka. A person being compelled to undergo narco analysis. A person who is called upon to undergo lie detector test. Thirdly, to undergo beep test. In these cases, though the Supreme Court did not specifically refer to Katikalu Ogad's case, Supreme Court ultimately held that these are cases wherein material is gathered from the accused involuntarily while when he is in a slightly subconscious mind, or that he is not giving the answers in a full conscious stage after administering his some medicine, etc. So ultimately, Supreme Court said that unless he voluntarily agrees for that, if the accused is called upon to undergo these three tests, it would amount to self-incrimination and violative of Article 23 of the Constitution. This is the basic law. Then we come to the question whether if a person is called upon to answer under Section 313 and on an incriminating circumstance, whether it would amount to self-incrimination. Secondly, can an adverse inference be drawn? I'll straight away take you to a few decisions on that point. They are, first decision is Ram Narayan More and another versus State of Maharashtra. Ram Narayan More versus State of Maharashtra, AR 1964 SC 949. That's the first decision. Second is Tanvi Ben Pankaj Kumar. Tanvi Ben, Tanviben, Tanvi Ben Pankaj Kumar versus State of Gujarat, 1997 7 SCC 156. And in Rajkumar Singh versus State of Rajasthan, AR 2013 SC 3150. In all these three cases, the question whether if a person does not answer to a question put to him under section 313 CRPC, whether it would amount, can the court take adverse inference, was considered. Evidently, the accused has got the right to remain silent, refuse to answer. But at the same time, what we have to keep in mind is that section 313 CRPC questions are administered to a person in compliance with the principles of natural justice. When material is gathered against him, which appeared to be incriminating him, should he not be given an opportunity to explain the incriminating circumstances which may ultimately be used against him? One aspect. Secondly, it will not attain the status of evidence. So on the question of or whether a person who is called upon to answer an incriminating question, and if he remains silent, can he be compelled to give an answer it? Supreme Court said no, he cannot be compelled. But at the same time, if a very patent, incriminating, crucial circumstance is put to the witness and he does not give an answer, court can take an adverse inference, supplementing the material which are already on record, only to the extent that it may go against it, that much. That was the law laid down in all these cases. Then the question that came up was, suppose a person refused to undergo blood test, refused to undergo DNA test. Can the court take adverse inference if it fails to undergo blood test, give sample for blood test, or to undergo DNA test, etc.? Invariably, in matrimonial disputes, this may arise. For conducting DNA test, can a person be compelled to undergo DNA test? Can a person be compelled to give his blood sample? Supreme Court said, though he cannot be compelled, if he refuses to undergo the test, court can take adverse inference. The decisions are Gautam Kundu versus State of West Bengal, AR 1993 SC 2295. Gautam Kundu versus State of West Bengal, AR 1993 SC 2295. Then Sharada versus Dharampal, 2003 4 SCC 493. In these two cases, the Supreme Court said that family courts have got the power to direct a person to give his blood sample. The court can also ask a person to undergo DNA test wherever it is required. But he cannot be compelled to give his blood sample. He cannot be compelled to undergo DNA test. But on the other hand, if he refuses to give the blood sample, or if he refuses to undergo DNA test, the court is entitled to draw adverse inference. Now we come to the last topic on that aspect is, can a person be compelled to undergo TI parade, test identification parade? That also the Supreme Court is consistent on the view. I'll give you a few decisions, then we will go to that. In Surajpal Singh versus State of Haryana, Surajpal Singh versus State of Haryana, 1995 2 SCC 64. Prem Singh versus State of Haryana, that was a decision in 2011. In criminal, I did not get the corresponding citation. I will give you the case number. Criminal appeal number 925 of 2009, decided on 2/9/2011. The third one is a rather recent decision that also I did not get the full citation. Rajesh and another versus State of Haryana, criminal appeal number 1648 of 2019, which was decided on 3/11/2020. In these three cases, the Supreme Court held that no person can be compelled to undergo TI parade. On the other hand, if you refuse to undergo the TI parade, court is free to take adverse inference. So these are the principles. So what is the ultimate conclusion that we are arriving at after discussing all these points? One, though under 114G and H, court is empowered to draw adverse inference, it should not draw adverse inference mechanically, or in every situation, court is not under an obligation to draw adverse inference. It is only a permissive inference. It is not a mandatory absolute inference. It's a question of fact and not a law, based on a question of law. The court should have due regard to the question, find out aspect whether the party who has got the burden of proof has discharged his initial burden. Then only call upon the other side to produce the evidence. And that evidence must be a crucial evidence, and that must be sufficient to clinch the issue involved. Otherwise, court cannot draw an adverse. These are the parameters which the Supreme Court over a period of time has laid down. Then ultimately the question is, I've been repeatedly saying the court is entitled to draw adverse inference. What is the inference that the court can draw? Suppose in a disputed bill, the case of a disputed bill, the other side is called upon to produce a bill and he comes and says that I am not in possession of the original will. Can the court arrive at a conclusion that will was in existence? Can the court take an inference that these are the dispositions made by the deceased person? Or suppose in the case of when a person is called upon to produce the account books in a suit for money based on a check, non-production, can the court lead to the conclusion that the plaintiff is only to be decreed? Can the court arrive at a conclusion that the check was executed by these persons? No, there is a limit to it. The inference that one a court can draw falls within the parameters laid down in section 114G and H. The inference under G is that if a material evidence is not produced, the only inference which the court can draw is that if it is produced, it will be adverse. That's much clear. Court cannot go to the extent of presuming things and conclude that the plaintiff's case stands proved because of the adverse inference. The limited adverse inference which the court can draw is if one person refuses to or withholds material document, the only inference which the court can draw is that if it is produced, that will go against it. If a person refuses to answer a question which is not under an obligation to answer, only inference which the court can arrive at is if it is answered, that may go against him. This much only. So these are the parameters. So thank you very much for giving me an opportunity to explain the concept of adversary. Now it is open for discussion. Yes.
Thank you very much. And in fact, I was just wondering, non-examination of a material witness or non-mounting onto the box of the plaintiff, what is the significance?
The significance is that, and that was the case which I referred to the last. That was a 3 judges bench decision.
Correct.
The court should consider whether one thing, whether he is holding the crucial evidence. 2, did he avoid the examination so that he will be compelled to answer these crucial answers? He may have an umpteen number of reasons for not coming to the court. There is no mandatory provision that the plaintiff or the party should come and tender evidence. So there is a limit to which the inference can be drawn. But in all the cases which I referred to, wherein the court took adverse inference, the court concluded that he is a person holding the crucial evidence. He purposefully withheld it. Thirdly, if that material evidence is led before the court, that may go against him. Only if these conditions are satisfied, then the court should. So that mere non-examination or not offering himself for cross-examination by the plaintiff or the defendant will not ultimately decide this issue. There should be a preliminary conclusion by the court that he is a crucial witness.
Absolutely.
Secondly,
sir.
that he is holding the witness, holding them. Thirdly, he avoided a cross-examination on the since he was sure that if he undergoes cross-examination, he will have to reveal these facts. Only in such circumstances, not otherwise. Not mere non-examination of the party involved. The court cannot draw adverse inference. Yes.
Mere non-parading of witnesses or unnecessary putting persons in the boxes of no consequence.
Cannot. That's what the Supreme Court said.
Evidence is to be weighed, not counted.
Counted.
Correct. That's where I come directly to Ramkumar, sir. Let us wait and let us not count it. Over to you, sir.
Wonderful topic selected and excellently executed by Brother Sunil Thomas. In fact, Brother Sunil...
Just before that, I should acknowledge 2 persons in that regard. One, choice of this topic was by Mr. Shyam Padman. Shyam Padman suggested about 1 month back. And then what he did was that recently I had occasion to attend a class in Bar Council. I was preparing for this. Then I told them that I have half prepared this topic. Shall I use that? Then I sought permission of Mr. Shyam Padman because I have already committed. Then he wanted to address the gathering before you go for Bar Council's function. Then I said, then second, I should also acknowledge that the topic was coined by Ramkumar, sir. Thank you for that, sir.
Shyam Padman. Okay. Anyway, excellent selection of topic and beautifully executed by Brother Sunil. Now, you have not left any stone unturned. In fact, in the context of TI parade, there's one decision of Supreme Court where the accused, after he was arrested, he wanted the TI parade to be conducted. Supreme Court said, no, you can't dictate terms to the prosecution. It is for the prosecution to decide. Beautifully executed. And in the issue regarding the non-mounting of witness box, in fact, I succeeded one case before Justice Paripurnan, where relying on a Supreme Court, because Supreme Court in that decision said, there's only the pleadings by one side and the counter pleadings by the other side. There's no evidence. The defendant had avoided the witness box, did not mount the witness box. So I relied on that decision and succeeded before Justice Paripurnan, who was a tough judge. I said this is a case where defendant had emphatically denied all my averments, but he had very, very significantly avoided the witness box, mounting the witness box. There's a direct decision, I don't remember that, by Supreme Court. Relying on that, I succeeded.
So there was one occasion when one bail application came before me in which one person stood accused of a 376 matter. He said that the girl has given names of several persons. Ultimately, one person was named by her. It was just not a complete name, but say Muhammad. I am not that Muhammad which she is referring to. If she is given an opportunity to see me, she will definitely say that I am not the person. He is also known by, say, I don't exactly remember the name. Name was Muhammad. Then I said, how can I give a direction? Then he cited an earlier judgment of our own High Court in which that identical situation, the court said, let he be given an opportunity to, the witness be given an opportunity to see this person and find out whether she identifies her. I said, I will not go by that. I did not. Anyway, I do not know what will be the ultimate favor, but why I did not go to that was there were several other reasons, material which were slightly against him. Because it so happened that this person claimed that he was abroad, but during the crucial day when he was in India. He was in India. That will be virtually putting a burden on the prosecution, giving an opportunity so that maybe by the
unjustifiable burden. Yes.
Correct.
You're right. In fact, before me, an argument was in a rape case. It was argued that a DNA test should be because a child was born subsequently. It was argued that a DNA test should be conducted. I refused that prayer, saying that this is not a case of paternity. A case of rape. Many. She might have had a sexual intercourse with so many persons. How can we?
So even this person, but that does not do the custody.
Exactly. Yes, wonderful.
Thank you so much, sir. Any other doubt? Anybody?
Thank you, Rangma, sir. Can I go to Ramesh, sir?
Yes.
It's a very good presentation on the subject, and everybody think that it is a right. That once a document has been withheld, the court has to draw an adverse inference. That is not correct. As regards that the power of attorney is concerned, even in that case, either the Supreme Court has explained, stating that if the power of attorney has the knowledge of those things which the other man has, then non-examination of that case, I think that it is a case of bona fide need to be proved, it appears. Yes. So that was a case where I think the Supreme Court has said that even in such cases, if the power of attorney has got the knowledge of the things which the original person is expected to give evidence, then non-examination of that person will not be having, but it is an appreciation. It is an appreciation of evidence as to whether it can be believed or not to be believed.
Correct, sir.
And in one matter, I think that in Supreme Court, I think it is by Justice Thomas, it is a circumstantial evidence. Suppose a crucial question under 313 has been put, and if it is not explained by the accused, then court can draw an inference to fill up the chain, fill up the chain of circumstances to complete the chain, and then that can be used against him. That was a decision where the circumstantial evidence it can be used as a material to link the chain, or the you can call it as
it can be treated as one of the links in the chain of circumstances.
That chain has been completed by virtue of that. Provided all other evidences are available, all other chain of circumstances are available, only this is a link to be proved, then that can be used for the purpose of completing the chain.
And it is very possible even if he gives a false reply.
Yes.
False reply.
But missing link theory, I have my own.
Correct, sir. How can that? Because by giving a false answer, or how can you take? Then you are going to substitute an adverse inference into an evidence. You are giving the weight of an evidence to that.
And this is not evidence also. 313 is not evidence.
It is only an explanation. It is an opportunity given to the other side to explain whether that is acceptable or not.
Exactly. It is only an implementation of the audio alterum partum.
Correct.
Because no part of the evidence that has been gone against an accused or brought by the prosecution should not be used unless it has been given an opportunity to explain it. Exactly. That's the only thing. Anyhow, it's a nice presentation.
Thank you, sir. But there's one thing also which I just missed was that, see, under Order 11 in civil cases, there is a very effective power of interrogatory as well as administrative interrogatory and also for
inspection of documents, everything is there.
Calling up inspection of documents. Why the Supreme Court said that whether you should consider whether there is a possibility before going and calling upon, assuming an inference, before raising the presumption, you should find out whether Order 11 can also be invoked, because what the Supreme Court's view was that Order 11 gives a very effective power.
Especially Order 11, Rule 21.
And
you can
because
strike
what
off the
happens
defense.
is that, Mr. Shyam, because what happens is that if a person who is called upon to answer the interrogatory or to permit inspection of records refuse to do that, in the case of plaintiff, he can be non-suited.
Oh, the defense can be struck off.
His defense can be struck off. So there is very effective provision is there. Why should we go for a presumptive adverse inference?
But even when the defense is struck off, he can participate in the cross-examination. He can cross-examine the plaintiff.
Only he can demolish the case of the plaintiff.
Yes.
Only thing he cannot prove his defense. That's all.
Yes.
Still that option is there, but very risky. Very risky.
Yes.
No, Order 11. See, in a CPC probably it may be available, but in the criminal cases, the non-examination of witness may arise in a case where there is a circumstantial evidence, but the evidence comes that there is a particular person who has seen the incident. That eyewitness was there, but that eyewitness was not even questioned. Then probably that may be a case where you can say when an eyewitness is available, non-examination of that person, unless the prosecution proves that is a false theory that has been put forward by the witness to help the accused. Otherwise, normally there is a misconception among the lawyers and also the people that the court can draw an adverse inference on that basis you can.
Correct.
But that is not.
And inference is only a very limited one.
No, inference unless leads to other evidences are available, and this is also one of the method by which you can establish that particular case. Then only the drawing out adverse inference will arise.
Correct, sir. Correct.
Very, very, very nice presentation, Sunil.
Thank you, sir. Thank you, sir.
Really, it's always everybody will have a rethinking of rejuvenating their own knowledge on this.
Correct, sir.
Nice.
Anybody else, Mr. Shyam?
Yeah, Dilip sir is here. Dilip,
Mr. Dilip.
I thought you would have some interrogatories to be put to.
Thank you, Sunil sir.
Thank you, Mr.
In fact, regarding adverse possession, my impression is that adverse inference can be drawn only on the omission to produce the best evidence, not any evidence.
Not every evidence. Not every evidence at all.
Only best evidence, omission to produce the best evidence, either by a competent witness or by documents. Only then adverse inference can be drawn.
Correct.
So that is 114G says only evidence, not document or witness. Then, suppose either of the parties opts to go under Order 11, then there is no question of adverse inference being taken because it's taken under at the time of trial or evaluation of evidence. But Order 11 comes on a pre-trial stage.
That's true. That is true.
So in case one goes for Order 11, then there is no question of adverse necessity to draw any adverse inference also.
Still.
These things will arise only in a case where, suppose a witness has been put to the witness box and it is certain denies us. You says that you may be having a document which you are not producing it. Then he says, I have a document. If the time is granted, I will produce it. Subsequently, he is not producing it, probably.
No, I meant Order 11.
Sir, what Dilip sir is saying that Order 11
does
not have anything to do with adverse inference.
Interrogatory and the discovery and inspection, if opted to by either of the parties, there is no question of trial even because.
Well, not that, Mr. Dilip. See, those are all cases where the undisputed facts are there, where you may get an answer. Suppose if I have got my own doubt, suppose just like putting a document during cross-examination. If I produce it earlier, probably you may deny or you may find out a reason for not to accept it.
Yes.
So there may question may arise.
At the time of cross-examination, it's there. But on non-compliance of a direction under Order 11, it entails in non-suiting the plaintiff.
Order 11 has its own repercussions. It has got nothing to do with adverse inference.
That is Order 11, Rule 21 says that the plaintiff shall be non-suited for non-prosecution. And not the written statement is struck, the pleading is struck down, but the defense is struck down.
Correct.
So the matter ends there. The matter ends there. It doesn't belong to or.
No. That is only against the plaintiff. He is not producing it.
That is
but you cannot draw an inference against the defendant that some document is with him. He is not producing it.
Non-compliance by the party to whom interrogatory has been served. If he does not obey the direction, then
his defense can be cut off if he is the defendant. But still, he has got the right to participate in the trial and cross-examine the plaintiff.
Yes.
That availability is there.
May I take...
just like a case where a written statement is not filed. Just like a case where...
That is there, but...
we can demolish...
Suppose the party says that I don't have the document with me. Can you draw an inference that he is having the document and he has not produced it? No. Unless you have got a prosecutive evidence shows you have got the document with him.
For that, he has to file an affidavit saying that I don't have it.
Yes.
In fact, Mr. Dilip, 1968 Supreme Court contains two diametrically opposite views. One decision says, unless he is called upon to produce, you can't draw an inference.
1968 Supreme Court 1413. That's the that's what.
Very same volume contains the
just opposite view.
Correct.
Opposite view. I remember my practice days.
May I read Order 11, Rule 21? Where any party fails to comply with any order to answer interrogatory for discovery or inspection of documents, he shall, if a plaintiff, be liable to have his suit dismissed for want of prosecution. And if a defendant, to have his defense, if any, struck out, and to be placed in the same position as if he had not defended. And the party interrogating or seeking discovery of inspection may apply to the court for an order to that effect. And order may be made on such application accordingly. So the matter ends there. The trial, it doesn't belong to a trial. That is my wrong reading on.
But not, is it mandatory?
Yes,
No.
It's mandatory. It's mandatory.
No, Mr. Dilip, I don't feel that it's a mandatory. It only says he shall have if the plaintiff is liable to be rejected, he shall have that may be the possibility. Does not mean that
he shall, if he is a plaintiff, he's liable to have his suit dismissed.
Liable
to have his suit dismissed for want of prosecution. And
he shall be liable for a dismissal. Yes. That means that
is one of the eventualities.
Even the eventuality. Because it depends on a lot of, it may be a pure question of fact. Suppose one person says, he is called upon to produce his account books. He says, I produced it before the chartered accountant, he did not give it back. On inquiry, I was found that he has lost from his office. Should not the court conduct an inquiry into that?
For that also, he has to file an affidavit or a reply.
So that there is what I feel is that there is always a risk of his suit being non-suited if he is a plaintiff. That's what the purpose of the Rule 21. That's all.
There also before ordering interrogatory or answering interrogatories, court will have to satisfy those questions are relevant for the purpose one. And only thereafter one. Not only that, when you are passing an order, court will say, produce document or file an affidavit as to the availability or not otherwise.
That is under Order 13, Rule 10.
Now we come to the second stage. When there is a direction, he fails to comply with the direction.
Yes.
What should be that?
Then it's not.
No, are you saying that when there is a direction and if the plaintiff is called upon to produce document or material document, he fails, do you feel that suit is liable to be dismissed?
Yes, that is what
non-suited. Liable to be does not mean that there should always be a dismissal. It may result in, it can only be interpreted like that.
In the absence of a satisfactory explanation. In the absence of a satisfactory explanation, suit is liable to be dismissed.
If there is satisfactory explanation, inquiry will be conducted on that.
Because, Mr. Dilip, the wording is that it does not say the suit shall be dismissed. It only says he shall be liable for dismissal, means there is still some point left behind.
No, he can give evidence. He can give evidence as to why he is not able to produce it or not. That also to be considered by the court.
And invariably, when a party is called upon to produce document, he will definitely file an affidavit. Either yes or no.
According to me, Order 21 Rule, Order 11 Rule 21 is not based on the principle of adverse inference or something like that.
No,
non-compliance of the direction by the court.
No, shall I ask you one thing, Mr. Dilip? Suppose he is called upon to, plaintiff is called upon to produce a document. That court says, produce the document or file affidavit. He files an affidavit stating certain reasons. Yes. Then should it automatically no, should not the court go into the question of the contents of the affidavit, and should it not be tested for cross-examination?
And technically, that also may be a case of refusal.
Maybe.
Technically.
Still, there is no obligation of the court to straight away reject it. It is liable for rejection. That's all.
Just like Order 7, Rule 11, it will not amount to rejection of the complaint at that time. You will have to conduct an inquiry, given opportunity as to why it is not being done.
It's a dismissal. It's a dismissal.
Dilip sir, adverse inference is not a statutory mandate. It depends upon the facts and circumstances of the matter.
That's discretionary.
I only said if it is refused to be complied with, not mere non-production of the document.
Exactly. So it should be a contumacious refusal.
Yes. It is not complied
Dilip with. Sir, had it been produced, it would go against you. That's all.
No, I said, that's why I said it doesn't have anything to do with adverse inference. I only say that the Order 21, Order 11, Rule 21 base is based.
So according to there is a consequential to the
Order 11, Rule 21 is a drastic remedy, but that does not preclude the court from drawing an adverse inference as well. Is my submission. I don't know.
Adverse inference is while evaluating the evidence. Production of documents doesn't involve evaluation.
Correct, sir. Correct. So at that stage, if you don't produce it, Order 11, Rule 21, striking out defense, everything will come in.
Yes.
But while evaluating evidence, it can be, had you produced that, when it is shown or if it's known that it's in your possession and you willfully or contumaciously did not produce it, then adverse inference can be drawn. That's my comment.
Similar is a position in Order 13, Rule 10, when you are called upon to produce a document or you file affidavit.
Correct.
Even if you don't produce it, there is no drastic order like dismissal or striking of defense under Order 13.
But the problem, Dilip, the problem will be if your proposition is accepted, that may lead to very, very difficult consequences. I'll tell you. I'll tell you one typical example. The example of workman which I said. Suppose, knowing that he is going to be terminated, he takes away the account book or even the must roll. Thereafter, files an application calling upon the management to produce the must roll. Fully knowing that he is in custody of the document. There is a possibility of if you are
I was only reading through Order 21.
There is always a risk involved because that only indicates that definitely that's a very, very effective provision.
Yes.
Only thing what you said is that I appreciate that you said that non-production of a material document, and I did not highlight that much. I said that, but I did not highlight because it's good that you have reminded me. It's only if a material document is material evidence is withheld, then adverse inference comes. That's true. Then secondly, even if we go by invoke Order 11 and the person who calls upon or invokes Order 11 fails to get material in his favor, still that does not preclude him from inviting for an adverse inference at a later stage. On a slightly different matter also, slightly different aspect of evidence. Still possible. Thirdly, you cannot draw a thing that although
yes, relying on the principle of honors of proof.
Correct.
Thirdly, sir, I mean, Dilip sir, that's where when the Privy Council and our Supreme Court said that it's an unwholesome practice to call for the other party to enter the box. In the sense, like plaintiff compelling the defendant or defendant compelling the plaintiff.
That is not yes.
You cannot compel the other side to mount the box.
Then you can only draw adverse inference.
Yes. Then regarding 313, I don't know how only much repetition I can ask that. If an accused doesn't offer any explanation I mean, not answer, offer any explanation to an incriminating suspect, would that entail in drawing adverse inference against him?
No, certainly.
No.
Never. Never. He is not even bound to answer.
Not answering or not giving explanation is different from not answering.
Yes.
Unless
He can deny.
Commission report comes into vogue, no necessary.
That's what I asked. He may answer or may not answer, but not offering explanation, because recently I read
how many cases the accused has offered explanation?
Right to remain silent
even in the case of bigamy, he will deny the first marriage.
313 is an occasion where he will even deny his paternity. PW1 has said that you are the son of so-and-so. False. Kalavana, Sheriyalla. That is standard answer given to all questions. Standard answer given to all questions.
Recently, there is a decision reported from Bombay High Court, Maharashtra High Court, saying that a person who was found in company with the deceased, last found in the company with the deceased, when asked, he did not offer any explanation, and that was made a particular ground for convicting him.
That is one of the grounds. One of the grounds for convicting. Yes, you're right.
Last scene theory.
Last scene together.
What the decision says is he did not offer any explanation during 330.
No. Last scene is a fact, but he did not explain why or
whether he was with him or not with him.
In 313, that is what.
Yes. But that is one of the circumstances which the court may take into account for recording a conviction.
No, suppose even assuming that last scene theory. Last scene theory is always a weaker evidence, because suppose if intervening time is larger,
yes,
then that is not going to have any impact.
Yes. My only doubt is whether adverse inference can be drawn for not providing any explanation to an incriminating circumstance.
No, suppose he never denies it.
Section itself is clear. You can draw. Court may draw.
That's all. It's only option given to the court.
Even
discretion.
If a person is not bound by law to answer, still if you refuse to answer,
unlike in a civil case, criminal case where he is, as Ramkumar often says, insulated with the immunity.
And the prosecution has got the burden of proving beyond reasonable doubt.
Yes.
That burden never shifts.
Then can that non-furnishing of explanation be taken as a ground to find guilt with him?
No, not that. There are convincing evidence to show he was the person immediately after that incident happened. And if he is not giving an explanation, if the court, other evidences are there, if he is not offering an explanation as a defense, the court may sometimes relying on the evidence. This also can be taken one of the circumstances to.
For instance, refusal to undergo TI parade, test identification parade, in spite of a specific request made by the prosecutor. No, I don't undergo. I don't subject myself to TI parade.
It's not refusal. It is only not furnishing of any explanation.
Not even that. He refuses. As an accused, he says, I got the right to silence. I don't want to undergo TI parade. That is something which is my personal thing. I don't want to be identified as the culprit. I am totally innocent. If that such a stand is taken, that may be a fit case where the court may draw an adverse inference for not undergoing.
Later you cannot say that I was not the person. Test identification was not conducted. No proper identification. That
but mere fact that he did not offer any explanation to a particular question. Explanation, I mean, not an answer. Explanation.
Dilip, everything depends on the circumstance. We do not know what is the facts in that case.
But
suppose there are evidence to show convincing evidence to show or unrebuttable evidence to show that he was the person last seen, and immediately after seeing him, immediately the incident happened. All those things were there.
Identity conclusively proved. Supposing identity is conclusively proved, but he refuses to undergo TI parade during stage of investigation. That may be a circumstance. That may be a circumstance.
Decision saying that he could not offer any explanation, so he should be.
You're probably relying on Justice Thomas' decision where missing link.
Maybe.
Anyway, thank you very much, sir. Because,
thank you.
Even on an earlier occasion when the promissory estoppel was taken, I missed the class. But this was one, I made it a point to attend this.
Thank you, Dilip.
Thank you, sir.
No, one thing is that Sunil was a teacher. So he knows the knack of teaching also.
He was my partner. I mean, when
we were together. We were together. Almost, yes.
He was a very good judge also. Sunil was, apart from being a teacher.
Sir, before we stop, I mean, Shoaib Hussain has got a question. Shoaib, please. Can you unmute? Shoaib, can you unmute?
You will definitely have a perplexing question.
No, sir. Good evening, sir.
Yes.
Good evening, sir.
Good evening.
Sir, I have a very simple question, kind of to this related topic, is that it is the duty of the prosecution to prove its entire case, and it cannot take any strength from the weakness of the defense. Now, my simple question is that given this fundamental principle of law, what I want to know is where that the defense has to prove by way of suggestion that no such incident took place, or the defense has a mandatory duty of putting suggestions in front of the prosecution witnesses. That is my first question. And second, if the defense does not put any question in the form of suggestions to any of the prosecution witnesses, will there be any adverse inference drawn by the court?
Can you just repeat the question? It's not very audible, Mr. Sure.
Sorry, sir. I'm sorry, sir. Sir, my question is that it is a duty of the prosecution to stand on its own legs to prove its own case, and it cannot take any strength from the weakness of the defense. So, in this principle of law, where is the duty of the defense to put suggestions to the prosecution witnesses? Because the defense does not have any responsibility to kind of put any suggestions or theories to the prosecution witness behind this principle of law. And second, if the defense does not put any kind of suggestions to the prosecution witnesses, then will the court draw any adverse inference to those facts and circumstances?
Definitely, the burden in a prosecution is entirely on the prosecution to establish the case. And it should be established by its own evidence, not stand on the weakness of the other side. But at the same time, does it not get supplement from the weakness also?
Yes, it will. It
can get supplemented from the weakness of the other side. Say,
supposing that the accused has mounted the witness box voluntarily, and during cross-examination, he made some fatal admissions. That certainly can be taken advantage of by the prosecution.
Then secondly, non-examination of certain witness can also be brought to the notice of the court in the process of cross-examination of other witnesses, so that you are putting a suggestion in the course of cross-examination, asking a witness that prosecution will not be examining such and such a witness because he knows the truth.
So what I mean to say, what is the underlying principle of putting suggestions to the prosecution witness when the prosecution, when during the cross-examination, it has been clearly established that the prosecution did not or cannot prove any case? What is the principle of law, sir?
Because the principle is that, see, that's the only time when the accused gets an opportunity to explain his defense also. See, what the defense lawyer does is through a series of questions put to the witness, prosecution witness, he develops his defense also. So he is not only trying to demolish the case of prosecution, he sets up his defense also. That he can do through the process of cross-examination. So the attempt in every criminal prosecution of the defense lawyer is twofold. One, demolish the prosecution witness. Two, develop his defense regarding the entire prosecution case as well as in vis-a-vis that individual witness through the process by putting a lot of suggestions. That's how you build up.
Yes,
and
sir.
you supplement it at the time of 313 while giving your explanation. Suppose you have taken up an alibi evidence. You are doing that through the evidence also, through the process.
I agree, sir. I agree with you. I am not going into this alibi evidence because that comes under the theory of proved and shall proved and disproved.
Correct.
So what I am saying is that if during cross-examination the prosecution case has been established, then why the defense needs to come up with his own theory of having a defense suggestion? That's what I mean to say.
Create a doubt.
He
has a right to create a doubt in the prosecution evidence.
Exactly, sir. So if the prosecution witnesses during cross-examination, the defense has able to create a doubt, then why does the defense need to give any suggestions? So that's what I mean.
Because the problem is that whether the case stands proved is a matter to be finally decided by the judge.
If I am permitted to give just a small example, sir, there are three prosecution witnesses. A says the incident took place near Calcutta. B says the incident took place near Bihar. And the investigating officer says, no, the incident took place in Delhi. Then, sir, during this theory, if during the cross-examination, the defense can say that there is theoretical evidence of difference about the place of occurrence, then obviously the defense did not put up any defense. That's what I mean to say, sir.
But suppose
they can rely on the disparity in the prosecution evidence.
Exactly, sir.
I understand your question. Now, but it is always a risky proposition to say that you are on one aspect, the prosecution case has to fail. You put on all possible defenses in front of the courts. Because ultimately we do not know. Suppose, I will tell you one marginal case. Suppose that happens in a border district, which is, you are giving an example which is very, very broad proposition. There cannot be any doubt ultimately except to acquit the accused. But it may not be very risky in every case. Suppose ultimately the court says, I am not accepting the evidence of first witness. I accept the second evidence. Then what remains the question of this contradiction? Court relies on one witness. I will put a more straight example. Regarding the weapon used, there is three contradictory ones by three witnesses. One person says, I feel it's a blunt weapon. The other says it's just got an edge, which is so that there is a narrow marginal difference between the weapon used. That happens invariably in every prosecution case. So that accused cannot take the risk of putting your defense only on one aspect alone. Always the defense lawyer will cover all the points let in by the prosecution, so that you have to set up a foolproof defense.
I see, sir. I see.
I will give more examples. Suppose one person in a suit, can you depend on the limitation aspect alone?
No, sir.
You have to challenge on merits also. On the belief that if ultimately the court is not accepting your contention on limitation and you are not challenged the plaintiff's case on any other aspect, you have to stand. Likewise, in the prosecution also, every prosecution lawyer will try to demolish each and every point marshaled by the prosecution. Otherwise, it is always a risky proposition.
I see, sir.
You do not know ultimately what the court has. Who decides whether the prosecution case has been proved? Only the court. When at the time of judgment, you will know.
I see, sir. See, sir.
So thank you, sir. One more thing. Defense lawyer, a crafty defense lawyer, covers all the points covered by the prosecution. Not only that, he will also still remain something for the appeal provision also. If not there is a conviction, in appeal I should be able to take up this contention. Even he thinks about that and puts a question like that.
Sir, thank you. So Ramkumar sir wanted to say something, sir. I think sorry for interrupting, sir.
No problem. No problem.
You better think about your appeal cases.
No, Dilip, for Dilip's question, I think in order 11 rule 21 says it is not automatic and the court cannot so modo do it. Dilip.
Sir.
Because it is no Supreme Court decision, but the commentary says that other High Court decision says that you must, when an application must be filed by the other side, because he has not produced away the document, the direction. So his defense will not be struck down or will not be. And again, notice will not be given out after hearing him only. Orders can be passed. Orders can be passed.
That is only when the other side wants an immediate order.
No, even otherwise, suppose if no order is called for, then only the later stage only the court can consider it. And it is a last resort what the commentary says.
Sir, on this point, there is judgment of the Honorable Supreme Court that Order 11 Rule 21 should be used as a last resort in 1978 Volume 4 SCC 188.
Yes. An opportunity must be always be given to the other side to call upon as to why it should not be done.
Yes.
Correct.
Suppose he is not filing an application, then ultimately you can argue later that he has not produced it, he has not answered it, so adverse inference can be drawn. That's all.
Sir, we have our brother Judge Sri Krishna Daglia. Sir.
Yes, sir. I was saying that there is a ruling of the Honorable Apex Court in Babar Sieving Machine Company versus Triloknath Mahajan, 1978, Volume 4, SCC 188, in which the Honorable Apex Court has said that even if there is non-compliance of an order under Order 11, the power under Rule 21 should be exercised only as a last resort and in rare cases.
That answers Mr. Dilip.
That explains the doubt raised by Dilip.
It is not mandatory.
Not mandatory. Correct.
In criminal prosecutions, as trial judges, we have seen some lawyers asking unintelligent questions during cross-examination and getting the news tightened against the accused.
It supports the prosecutor. Virtually helps the prosecutor.
So, in one case, the prosecutor asked, why not prepare the 313 examination? Wait, let the cross-examination be over. You will get more incriminating questions. Another judge asked the defense lawyer after his unintelligent cross-examination, Mr. Defense Lawyer, do you have any objection in acquitting?
Or you are very, very particular that your party must be convicted.
Such things happen during trials.
That is plugging the holes of the prosecution case. Yes.
As we come to the end of the 280th session, thanks are due definitely to Sunil sir. I mean, a wonderful presentation. The topic, though you said suggested by me, but it is something that has been vexing very legal minds in the sense like what is adverse inference, where and how it can be invoked and all that. Concept and the situations. You beautifully covered it, sir. Thank you very much. And
thank you so much, sir. It's my pleasure.
Justice Ramkumar sir, Justice Ramakrishnan sir, and all of you wonderful participants. Thank you for being part of this 280th session. And we hope to have further deliberations and discussions on different nuances of law in the forthcoming sessions. Till then, please do take care and stay safe.
Thank you. Good night.
Good night. Good night. Good night.